Things that were legal until one person ruined it. Darling, every law on this list has a date. Before it, legal. After it, criminal. The gap between the two is one documented moment. Killing the president was not a federal crime until 1965. Interracial marriage was a felony until one couple was arrested in their own bedroom. And every time you cross the road in the wrong place, that was once legal too. The document that made it a crime is always in the archive. The world before it is gone. Let us begin. Level 1. November 22nd, 1963. John F. Kennedy is shot in Dallas, Texas. Lee Harvey Oswald is arrested within hours on state charges. Texas murder law. There was no federal law making it a crime to kill the President of the United States. There had never been one. When Lincoln was assassinated, when Garfield was shot, when McKinley was shot, in every case, state murder charges. Not once had Congress made it a federal offense. The federal government had no jurisdiction. The FBI was investigating because Hoover decided the FBI would investigate, not because there was a law requiring it. J. Edgar Hoover's first memo after the assassination, dated November 22nd, 1963, hours after Kennedy was shot, notes the jurisdictional problem explicitly. The memo is in the National Archives. The Warren Commission's final report, published September 1964, contains a specific recommendation on page 25. A federal statute should be enacted making presidential assassination a federal crime. Congress passed Title 18, United States Code, Section 1751 in 1965. The law was signed by Lyndon Johnson. It made killing the president a federal crime with a minimum sentence of life imprisonment. The law was passed 731 days after the assassination it was responding to, before November 22, 1963. Legal under federal law to kill the president. After 1965, federal crime. The Warren Commission memo is in the archive. The Hoover memo is in the archive. The 731-day gap is in the congressional record. All three documents are still there. One observation the Diva would be failing her professional duties not to make. Lee Harvey Oswald was shot and killed by Jack Ruby 2 days after the assassination, in front of live television cameras, in front of 70 police officers in the basement of Dallas Police Headquarters. Oswald was never tried. The case was never prosecuted. The filing system kept the footage. The filing system also kept the fact that the man accused of killing the president died in police custody, before any federal law even existed to define what he had allegedly done. The 731 days between the assassination and the law. Both things are in the filing system. Level 2. Dueling was legal. In most of the United States in 1804, two men could agree to stand a prescribed distance apart, fire a pistol at each other, and have this considered an honorable resolution rather than a homicide. The practice had been imported from Europe, codified in the Code Duello, a formal written set of rules governing how duels should be conducted, and was a recognized mechanism for settling matters of honor among gentlemen. Alexander Hamilton had opposed dueling publicly, and in writing for years, he had lost his son Philip to a duel in 1801. He had written to his second, Nathaniel Pendleton, the night before his own duel with Aaron Burr, stating his intention to withhold his fire, to throw it away, rather than shoot at Burr as a matter of conscience. The letter is in the Library of Congress. It is dated July 10th, 1804. the night before. He documented his intention not to shoot. The following morning, at Weehawken, New Jersey, he didn't shoot. Burr did. Hamilton was shot through the liver. He died the following day, July 12, 1804. He was 49 years old and owed approximately $55,000 in debt, worth approximately $1.4 million today. The coroner's jury in New York returned a verdict of murder against Aaron Burr. New Jersey also indicted him. Burr was, at the time of both indictments, the sitting Vice President of the United States of America. He returned to Washington. He presided over the Senate under 2 murder indictments. He wrote to his daughter that the work of the Senate gave him something constructive to do. He finished his term. He was never tried for the murder of Alexander Hamilton. He died in 1836. The indictments are in the court records of New York and New Jersey. Both are still there. The letter in which Hamilton documented his intention not to shoot is in the Library of Congress. That is also still there. The duel that ended dueling's social legitimacy in America killed the man who had designed the country's financial architecture and left the man who killed him to finish his term as vice president. Subscribe before Level 3. Level 3 is when the automobile industry invented a crime that most people commit every single day without knowing it used to be legal. And they documented it. Of course they did. Aaron Burr presided over the Senate under murder indictment and finished his term. What comes next is a geochemist trying to date the age of the Earth who discovered that an industry had contaminated the entire global food chain and then had his funding withdrawn 4 times. He published anyway. The defunding letters are in the archive. So is the paper. Level 3. Claire Patterson was a geochemist at Caltech trying to calculate the age of the Earth. His samples were contaminated. Everything was contaminated. Ocean sediment, Arctic ice cores, human blood, food. The contamination was from tetraethyl lead, the additive in leaded gasoline introduced in 1923 by the Ethyl Corporation, a joint venture between DuPont and General Motors. Tetraethyl lead made engines run smoothly. It also entered the atmosphere through car exhaust and settled into everything. The Ethyl Corporation's own researchers had died of acute lead poisoning. During the additive's development, in 1924, at Standard Oil's Bayway refinery in New Jersey, workers began hallucinating, convulsing, and dying. 15 hospitalized. 5 died. The Ethyl Corporation's response: a press conference in which representatives drank small quantities of tetraethyl lead to demonstrate it was safe and called the product ethyl, because they had determined that associating the product with lead would damage sales. The press conference is documented in contemporary newspaper accounts. They named it ethyl. The lead was still in it. Patterson published his 1965 paper, Contaminated and Natural Lead, Environments of Man. His central finding: lead levels in modern human blood were approximately 1,000 times higher than in pre-industrial human remains. 1,000 times. The Ethyl Corporation contacted the American Petroleum Institute and requested that Patterson's research funding be withdrawn. It was withdrawn. He reapplied. Withdrawn again. 4 times. 4 documented funding withdrawals. He continued with alternative funding. He kept publishing. The EPA began restricting leaded gasoline in 1973. The full ban was completed in 1996. Leaded gasoline had been legal since 1923. Made illegal, in stages, under pressure, over decades. because one geochemist kept publishing despite 4 documented attempts to stop him. Patterson's paper is in the scientific record. The Ethyl Corporation's 4 defunding letters are in the institutional archive. Both are still there. 1 geochemist, 4 defunding attempts, 1 paper. 31 years to the full ban. What comes next is shorter. June 2nd, 1958. Police enter a couple's bedroom with flashlights. The couple are married. The marriage is illegal. The sentencing judge writes that Almighty God created the races and placed them on separate continents. That sentence is in the court record. The Supreme Court ruling that overturned it is 9 pages. Both are still there. Before level 4, one observation. Every level in this episode has the same architecture. Something was legal. One documented moment changed it. The document that created the change is in the filing system. The world before, the change is not. The 731-day gap. The duel that ended dueling's legitimacy. The 73 years of leaded gasoline. Level 4 is the most personal. One couple. One bedroom. One judge's statement. 9 years from the bedroom to the ruling that changed 16 states simultaneously. Level 5 is the one that affects you specifically. Today, every time you cross the road in the wrong place, something that was legal until the automobile industry wrote down the reasons why it should not be. Level 4, June 2nd, 1958. Mildred and Richard Loving are asleep in their bedroom in Central Point, Virginia. Police enter with flashlights. Richard Loving is white. Mildred Loving is black and Native American. They are married. Marriage between a white person and a non-white person is a felony in Virginia under the Racial Integrity Act of 1924. They are arrested in their bedroom and charged under that act, both of them, in their bedroom, for being married. They pleaded guilty. Judge Leon Bazile sentenced them each to 1 year in prison, suspended on condition that they leave Virginia and not return for 25 years. His sentencing statement is in the court record of Caroline County, Virginia. He wrote, "Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. But for the interference with his arrangement, there would be no cause for such marriages. The fact that he separated the races shows that he did not intend for the races to mix. That statement is in the filing system. It is still there." The Lovings appealed. The Virginia Supreme Court upheld the conviction. They appealed to the United States Supreme Court. On June 12, 1967, 9 years after the arrest in their bedroom, the Supreme Court ruled unanimously in Loving versus Virginia. Chief Justice Earl Warren wrote the opinion. It is 9 pages. The ruling. Under our Constitution, the freedom to marry or not marry a person of another race resides with the individual and cannot be infringed by the state. Interracial marriage became legal in all 16 states where it had been a crime, simultaneously, in one ruling. 9 pages, 9 years from the bedroom. Mildred Loving died in 2008. Richard Loving died in a car accident in 1975 at age 41. They had 3 children. Neither was a lawyer or politician or public figure. They were a couple arrested in their bedroom. The filing system kept the arrest record. The filing system kept the judge's statement. The filing system kept the ruling. All 3 are in the same archive. For 66 years, one couple, 9 years. 16 states changed by 9 pages. What comes next is the one that affects you. Today, every time you cross the road in the wrong place, something that was legal until the automobile industry invented a crime for it. They invented a word first, designed to make you feel stupid. Then they lobbied for the law. The lobbying documents are in the city archives. The word they invented is in every dictionary. The crime is still on the books. Level 5. Before the 1920s, pedestrians had legal right-of-way on every road in every American city. Roads were shared public space. Cars were the new arrival. They were expected to yield. If a car hit a pedestrian, the driver was at fault. A pedestrian crossing the road was exercising a right that had existed for as long as roads had existed. It was not a crime. It had never been a crime. Between 1920 and 1925, automobile deaths in American cities rose as car ownership increased. The public response was anger at cars. In 1923, the city of Cincinnati put precisely such a proposal to a public vote. The automobile industry lobbied against it. The proposal was defeated. The solution was not to slow the cars. The solution was to redefine who had the right to be on the road. The word jaywalker was coined and spread by automobile industry interests in the early 1920s. Jay was period slang for an unsophisticated rural person who didn't know city ways. A jaywalker was therefore a country idiot who walked into traffic. Because they were too stupid, the National Automobile Chamber of Commerce and local automobile clubs coordinated campaigns with newspapers. The word appeared in major newspapers across America throughout the 1920s. The word was not organic. It was placed. Jaywalking laws spread through American cities throughout the 1920s and 1930s. By 1930, crossing the road in the wrong place was a criminal offense in most major American cities. It remains a criminal offense in most American cities today. The lobbying records of the National Automobile Chamber of Commerce are in city government archives. The 1923 Cincinnati ballot measure is in the city archive. The campaign coordination materials are in newspaper archives. The word jaywalker is in the dictionary. Every dictionary, defined without reference to its origin. The crime is on the books. Every municipal code, enforced without reference to who invented it. Before 1920, crossing the road was a right. After the 1930s, a crime. The automobile industry wrote down why it should be a crime. The filing system kept the documentation. The filing system also kept the crime. Every law on this list has a date. Before that date, legal. After that date, criminal. The filing system has every date and every document that created it. The 731 days between a president's assassination and the law that made it a crime. The letters in which Hamilton wrote that he would not shoot, still in the Library of Congress. The 4 attempts to defund the geochemist who proved the industry was poisoning everyone, still in the archive. The sentencing statement and the Supreme Court ruling, side by side in the same archive, 66 years later. And the lobbying documents that invented the word and wrote the crime. In the city archives, in the newspaper records, in every dictionary. The filing system kept all of it. The filing system did not keep the world before the document. You are standing on the pavement. It is illegal to cross the road in the wrong place. The meeting where they decided it should be illegal is in the archive. The archive is open. The filing system, darling. It keeps everything.